I would like to remind you that it is organized by the efforts of the few Ukrainian NGOs, namely the Media Initiative for Human Rights, the Ukrainian Helsinki Human Rights Union, with the support of the USAID Human Rights in Action program. And in this series, we try to bring the international law perspective within the Ukrainian context and vice versa. And so far, it's been a very insightful and important experience for us, as well as for our audience. And I would like to admit that at least in the list of those people who pre-registered to this webinar, there were lots of professionals from the actually legal professionals from both like Ukrainian courts, prosecutor office system, and also various lawyers who are also, of course, naturally very interested in our today's debates. I would like just to start with this general information that there has been lots of debates concerning ICC in Ukraine in these previous years, and mostly these debates were related to the, as Katerina says, this accusations perspective. So we all the time try to discuss whether within the Ukrainian case, we had any chances to bring to responsibility, first of all, Russian, so to say, those people who are sitting in Kremlin and those who, as Ukrainians believe, commit war crimes and crimes against humanity in the territory of Ukraine. But we have never been discussing, at least I don't remember any public debates or events dedicated to this specific defense perspective. And I'm really glad that we will have today this topic with such a distinguished speakers. And I will, in a minute, I will give the floor to Katarina Busol to introduce our guest today. Before that, I would like to remind about some technical details that are very important. You can follow this webinar in English or in Ukrainian. In order to choose the Ukrainian interpretation, you should press the button, the globe button in the bottom of your screen and choose the German option. Then you can ask your questions here in the chat in Zoom, but also you can ask your questions in the Facebook where you have where we stream actually this webinar, and you also can follow the streaming of this webinar in the YouTube. So please ask your questions. And let me again remind to the panelists that we have this interpretation, and please remember about that. And we would like to make sure that all the attendees and all our audience does understand us and can follow the interpretation. So, and also one kind of request from the audience, we asked our audience to kind of propose their questions to our panelists, and one of the requests was related to the like particular cases that you have worked with. It would be great if you can bring those examples from your practice, because your practice is just impressive, and of course we would like to hear all those examples in order to have a chance to compare it maybe to Ukrainian context and to have some kind of insights from that as well. So without further delay, I would like to give the floor to Katarina Busol in order to introduce the panelists. Thank you.
Dear colleagues, good afternoon. And without further ado, I'll introduce our impressive speakers today. Many thanks to Кейт Ґібсон and Dov Джейкобс for joining us. Kate is an Australian lawyer specializing in international criminal, humanitarian, and human rights law. She's been appearing before the international criminal courts and tribunals since 2005 and has been involved in such all-known cases like those of Bosco Ntaganda and Jean-Pierre Bemba at the ICC. She's also been a legal consultant to the independent international fact-finding mission on Myanmar, and Kate also represented victims in the first case before the extraordinary chambers of Phnom Penh in Cambodia. Dov Jacobs is also an international criminal lawyer and an assistant professor of public international law at Leiden University. And I must say that I know quite a few Ukrainian students who were Dov students and are just in awe of his teaching. Dov is also a practicing lawyer. He's a defense counsel at the ICC and the founder of Strategic International Legal Consulting. Dov has been involved in a number of cases, such as those of Lauren Gbagbo, Mahmoud Said, and that of Felician Kabuga. He has also been involved as an amicus curiae in both the Afghanistan and the Palestine situations at the ICC. Without taking the floor any longer, I currently give the floor to our speakers who will make brief introductions, and then we will turn to the questions. As Maria said, you are very welcome to submit your questions either here in the chat function or on Facebook or YouTube in the commentary section, and we will read them from there. Kate, the floor is yours.
Thank you very much, Katerina and Maria, and everyone here today for having invited Dov and I to come and speak with you on representing accused before international courts. I had the real pleasure of being together in person with Dov and Katerina at the end of 2019, when we could still all be together and discussing some of these issues about representing accused and fair trial rights. So I'm really happy to have a chance to continue that discussion today. And before the webinar, Katerina said something very interesting to us about how today we should talk about the role and responsibilities of defense counsel not just being limited to representing our clients. And that's a really interesting way of categorizing what it is that we do, that our role isn't just limited to defending that man or that woman, but we play a larger role in the International Criminal Justice Project, and one that's really often misunderstood and mischaracterized. You know, often we're sort of associated with our clients. We're seen as anti-establishment, anti-truth, anti-justice, and that's really the wrong mindset, because defense lawyers aren't the enemy. We're not even this sort of necessary evil. We're part of this criminal law justice project, and we contribute to it and we strengthen it. So I thought I'd just spend 5 minutes today telling you what I think are the two biggest fallacies, the two biggest myths about the work of defense counsel, and telling you why they're wrong. And the first one, myth number one, is that the role of defense counsel is to try and get their clients acquitted. That's not accurate. That's not what we're doing. That's not an accurate description of our role within a criminal trial. If I had to try and sum up what our role is in one phrase, it would be helping the judges by testing the prosecution evidence and fighting for the fair trial rights of the accused. Defense lawyers are this living, breathing safeguard for fair trials. Because if the trials aren't fair, if trials aren't legitimate, then we should all go home. There's no point to us doing this at all. It will cause more harm than good. The defense lawyers are these fair trial warriors in the courtroom, standing up every day and reminding everybody about the human rights that are at play, the fair trial rights of the accused that have to be respected. We're the ones standing up and saying, you know, tell the accused what the charges are, make the indictment more detailed, disclose exculpatory evidence, look for exculpatory evidence, keep the trials in open session, remember the burdens of proof, remember presumptions of innocence, remember equality of arms. That's how we strengthen, that's how we contribute to these trials. We are this moral conscience in the courtroom. And then the second half of our role is helping the judges by testing the prosecution evidence. What do I mean by that, by testing prosecution evidence? Well, the prosecution comes and presents its case. It gives the judges its theory, its case theory, and then brings oral evidence and documentary evidence. And the prosecution has that all admitted into the record of the case, essentially to try and prove three things. The first thing the prosecution's trying to prove is that the crimes actually happened. The underlying acts that we're talking about, that they happened. The pillage, the murder, the attacks, rape, torture, that happened. It's the first thing. The second thing, they're trying to show that these crimes rise to the level of international crimes. So they're not just ordinary crimes, they're war crimes because they're committed in the backdrop of an armed conflict with a link to the armed conflict. They're not just ordinary crimes, they're crimes against humanity because they're committed against a civilian population. So that's the second thing. So firstly, that crimes occurred. Secondly, that they're international crimes. And thirdly, the third thing the prosecution's looking to prove is that this accused in this trial is responsible for those crimes, that he planned the crimes, that he ordered the crimes, that he was part of a conspiracy to commit them, that he was in charge of the perpetrators. And that's what we call the linkage evidence between this accused and the crimes. Our job is to test all of that, to help the trial chamber to see whether that they can rely on this evidence, whether or not it's credible evidence, whether it's relevant evidence, whether it's reliable evidence. Our testing of the evidence helps the judges in that way. And how do we do that? We can do it through cross-examining prosecution witnesses. We can do it through challenging documentary evidence when it comes to court. Or we can do it through putting on a positive defense case, right? So calling our own witnesses and our own evidence to try and test what the prosecution is saying. And essentially, that's what our job is about. And the reason that we do it is so at the end of the day, when the trial chamber deliberates and makes its findings of fact that it then relies on to make legal findings, it's making those findings knowing that the evidence it's relying on has been thoroughly tested by the defense lawyers. See, we're very helpful to this process, which brings me very quickly to my second myth, which is that the role of a defense counsel involves denying that crimes occurred. No, that's not what our job necessarily entails. If you go back to those three things that I was telling you that the prosecution had to prove, most of the time, the defense counsel isn't going to be challenging all of these three things. On a lot of occasions, we're not going to be disputing that the crimes themselves occurred. These are crimes that happened. These are historical facts in many of these cases. And oftentimes, we're not even going to be challenging that they rise to the level of international crimes. You know, in Rwanda, we weren't saying that these crimes weren't genocide. In the former Yugoslavia, we weren't trying to say that certain acts didn't rise to the level of crimes against humanity. In some cases at the ICC, we are challenging at that level. But at the most part, the role of the defense is trying to test the prosecution evidence about the link between the crimes and this accused. Really testing whether or not this accused gave those orders or was responsible for those troops, or gave enough assistance that you can say that he was aiding and abetting these crimes. And so most of the time, to try and give you a practical example, from the Bemba case, which was a case at the ICC against the former vice president of the DRC, of the Congo. That case involved a lot of instances of rape and sexual violence, and the prosecution would bring rape victims to give evidence. As Mr. Bemba's defense counsel, we weren't trying to challenge these victim witnesses and say that they hadn't been raped or that they were making it up. That wasn't our job. At most, we would ask them some questions about dates and times to see if our clients' troops could have been there, maybe about the uniforms that the perpetrators were wearing to see if they could be properly identified. That's where we were trying to test. So this more general idea that defense counsel are sort of these revisionists or try to deny crimes or rewrite history just isn't accurate. I was excited to see that Dov was taking notes because I hope he's going to come back and challenge some of the things I said, which he normally does on panels. So maybe I'll throw the floor straight over to him and see if he has a different perspective on any of the things that I've said.
Thank you so much, Kate. Dov, the floor is yours.
Thank you, Katerina and Maria, for the pleasure of being here and for being on the panel with Kate. As Kate said, that this is not our first rodeo being together on the panel, so it's better live, especially for the drink we can have afterwards. But anyway, soon, I hope. I don't disagree with you, Kate. I might present things slightly differently, and again in the introductory section, just come back on a few points you mentioned, and essentially I'll discuss two issues. One is why we're important, as Kate said, and my second point is why nobody cares. So that would be about the structure. So maybe my second point will be a bit less positive than what Kate was saying. So on why we're important, and I can only echo what Kate said, and I'll actually quote Kate. I remember a few months ago, I forget when exactly, but there was, we spent way too much time on Twitter. There was this tweet saying, can you say something about your job, which is true, but nobody will believe? And Kate had put, defense lawyers are human rights champions. I'm paraphrasing, but that's essentially what Kate said. And that's really important to say. We're doing human rights. We're talking about the human rights of the accused, and we're talking about the human due process in general. Katerina, you mentioned my students. Usually when I teach ICL, I start with this falsely simplistic question, which is what are the purposes of international criminal law? And it's quite interesting. I mean, I've been doing this for 10 years, but usually I get everything except due process in the answer. I get truce, peace, reconciliation, etc. I never get due process. I sometimes get due process. I might have a defense lawyer in the room, and usually if I'm invited, the fact that I'm there gives them a hint at what answer I'm expecting. But usually if you look at different objectives of international criminal law, which are attributable to international criminal law, like peace, justice, reconciliation, reparations for victims, when you think about it, all of those objectives can be achieved outside a courtroom. You can have a truce commission, you can have a reparations process, which is not linked directly to criminal responsibility. You can have a historical commission, which establishes a truce, etc. Even punishment, to be a bit provocative, you can take someone and accuse him, put him against a wall and shoot them. That's retribution in the strict sense of the term. But that's not the justice we have in mind. So actually what really makes ICL stand apart from every other mechanism is not its objectives of truce, peace, reconciliation. It's fair trial. It's a choice we've made as a society. And it's really important. And you see that in American movies. It's not a technicality. Due process is not a technicality. No defendant ever gets off on a technicality. He gets off because the evidence was not good enough, because his rights were respected. So that's, talk about cliches that we challenge with Kate. That's one of them, this idea of a technicality. Due process is a normative choice in the same way that the choice to punish genocide is a normative choice. We decide to use due process. We contribute to the truth. I mean, I could speak for hours on why we're important, but I won't repeat everything Kate said, but we test the evidence. And I'll even go further than Kate when she says we're not here to rewrite history. We're here to write history. we're here to help the judge see out of the evidence something more subtle, possibly, and often than what the prosecutor puts forward. And, Kay can talk about this better than I can, but, in the Rwanda cases, even nobody can accuse ICTR judges of being, genocide deniers. But what came out of the judgments was more subtle than what the prosecutor was alleging in terms of how the genocide was actually organized, at what level of government it was organized. It's not the genocide that the prosecutor sold. And that was only possible because the defense, in most cases, did its job in explaining the evidence, in saying you can't just accept a narrative on face value. And it's the same in the Bagbo case I worked on. The Bagbo case, we, based on the prosecution evidence, explained to the judge a different narrative, which, and you'd say I'm biased, but which turned out to be closer to reality. And that's what the judges said when they acquitted Laurent Gbagbo. So we didn't rewrite history. We contributed to the understanding of the evidence, which was not the prosecutor's understanding. And when you're on the side of truth, you're always going to win. And Kate said we're not here to acquit our clients, but it is an injustice if our clients are not acquitted when there is no evidence. I would say that about the situation. That would be unjust. And that's why the burden of proof is on the prosecutor. He has to prove the charges, as Kate said. We don't have to prove anything. Obviously, as a good defense lawyer, you're going to bring your own case, your own counter narrative, because psychologically for the judge, saying that the prosecutor is wrong is one thing, but you need to give a positive alternative to the judge psychologically, if there is one, obviously. So if you actually know what happened, you tell the judge, you don't just keep it for yourself. But the burden is on the prosecutor, because this is what we're, this is, again, the choice we've made. And I'm always struck, and it will be my transition to the second part, why nobody cares. I'm always struck by conversations I have with people domestically, friends of mine who are not in law. They will, if you ask them about due process, about presumption of innocence, they'll all agree with it. But when it comes to international criminal law, suddenly they don't. It's not the same. But the reason why we have due process is that, and sorry for being banal, but we choose a system where we want to make sure no innocent person goes to jail. And if the consequences of few guilty end up in free, then it's a choice we make, because there's no perfect system. Because there are humans, prosecutor, defense judges are all humans and all imperfect. So we have to choose a system which is either every person who is guilty goes to jail with a few innocent people, or everybody innocent stays out of jail, and maybe sometimes a few guilty people will stay out of jail. I prefer the second solution. And we would all do. If we're unjustly accused domestically, we will want our presumption of innocence to be recognized. That's the whole point of a principle. It applies whichever the circumstances, whatever our moral preferences, whatever the gravity and how horrible the crime is. That's the beauty, and that's why we should be proud of such a system in our democratic societies, is that even if you're accused of the most horrendous crimes, we treat you fairly. So that's the passionate call. Now, why don't people care, especially in international criminal law? For many reasons, which just to plug my own work, I've written extensively on this, why in ICL nobody cares about the accused or the presumption of innocence. But just a very short summary. Obviously, when we're talking about international criminal law accused, we're talking about people who are in the news. We're talking about events which are very much documented in NGO reports, in the media. So how can there not be a presumption of guilt? He must have done something wrong. And you see that even in very genuine, honest academics. I have a colleague who does extraordinary work on evidence at the ICTR, ICTY, showing how the evidence is weak, etc. But she concluded her book by saying, but that's okay because they're guilty of something. I'm hardly paraphrasing. And I challenged her on it once. And she said, yes, I agree. I mean, that's what I think. It's okay to have a system where the evidence is less good, because they must have done something. So do you have this kind of presumption of guilt? The other reason is those other objectives I mentioned before. rights of the defense are continuously balanced out, what I would call balanced out, for other objectives, rights of victims, right to truce, difficulty of investigations, which we can discuss later in more detail if you have any questions on that. But it's notoriously difficult to investigate in a conflict zone. But then you have a real, and this, I think Kate and I would both acknowledge that it's hard for the prosecutor to investigate, but at some point comes a normative choice. Do I lower the bar to make sure that less solid evidence is accepted, or do I maintain the principle, which is, ultimately, it's not my problem as defense that you have difficulty investigating. We set the standard here, and you have to respect it. And I shouldn't suffer from the fact that you can't access a crime scene and the states are not cooperating, etc. It's a real choice, but it's not obvious. It shouldn't be obvious that necessarily we lower the bar in terms of corroboration, in terms of forensic evidence, etc. The third reason is the collective dimension of international crimes. And I'm just nerding it up for a second here. It's more my academic side, but we're talking about collective crimes, collective victimhood, collective perpetratorship, massive historical and political context. And so the responsibility of the accused is ultimately diluted in that. It's less important to look, and even when it's big accused like Bagbo or Bemba or Karadzic or Mladic, even with those high-level accused, we're still diluting their responsibility and the idea of collective responsibility of joint criminal enterprise, etc. So it seems less, because we're talking about collective aspects, it's not as bad to not respect the rights of the defense, because we're talking collective dimensions of the situation. And I'll conclude here with linking the two parts. Is that one of the reasons people don't like us is that we show where the system is failing. And nobody likes that, shoot the messenger. And I use this metaphor in one of my articles where, it's like international justice is looking at the mirror in Snow White, please tell me who is the fairest. And we are the defense saying, you're not fair. And people want to try and break the mirror because we're, as Kate said, and we're in court every day saying, no, I'm sorry, this investigation was not right. The evidence is not good. This document containing the charges is not specific enough. The presumption of innocence is not respected. So there's ultimately this feeling that we're shooting, that we're undermining the system when ultimately we're only trying to make it better collectively. We're part of the system. So I'll just conclude there, even though I could go on forever, but I'm sure there are many questions that arise from that.
Thank you so much for this great introduction, and thank you for covering this motivation aspect, and that's very valuable and important. And as I announced, I will ask some naive probably questions, and I have two for the beginning. First of all, elaborating more on what you have been just talking about, I'm just wondering about your personal choice. I mean, what was the incentive for you personally to do this particular job? Because, for instance, I have noticed in the bio of Kate that back in, if I'm not mistaken, to 2007 to 2008, you represented victims in the first case before the extraordinary chambers in Phnom Penh in Cambodia. So, and then you shifted to being a counsel of accused. So what made you to make this choice? And also some really kind of technical question, because I think that our audience is wondering how this whole kind of defense defense aspect of the ICC is working. So we have quite a limited cohort of people who are able, who are capable, and who are allowed to be a defense counsel. So how it all works, because as of now, there are no Ukrainian lawyers, for instance, no Ukrainian consuls working in this particular field, and it's not easy to become one. Can you tell us a little bit about this procedure and how it works, and how is it possible to become a defense counsel at the ICC, and how complicated is that?
Thank you for the question. I'm happy to start. I wish I could say I became a defence counsel because I had this burning desire to ensure that trials were fair, but I didn't. And I think you'll find most of us sort of fell into it. I literally went to replace someone for a trial in Rwanda in 2005. A girl that I knew from international criminal law studies was working as a defence legal assistant for one of the Rwandan cases, a case against 4 high-ranking members of the Rwandan armed forces during the genocide. And she told me about this position. I remember thinking, I cannot believe that's your job. I cannot believe you sit next to those men in court. I cannot believe you represent them. That is horrific to me. I would never do that. And for some reason, she had a clash with another case, and I was supposed to go and sit as a defence junior for 2 months in 2005. And, you know, was so scared and actually couldn't believe I was doing it, but I didn't have any other job options. And I went, and after 2 months, that was the start of 5 years for me at the Rwanda Tribunal, representing these accused. I really saw quite quickly that, particularly the case of my client, he was charged with being a commander of troops who were committing genocide, but the prosecution didn't have evidence demonstrating that he had effective control over the troops and could prevent and punish him. And I stayed on that team for several years, and in the end he was acquitted at first instance. So I had this first experience with defending accused, and it's sort of become an addiction of mine because I find the work that we do so worthwhile, and I also enjoy being the underdog. I don't know if that translates, but you know, being the one who always has to fight a bit harder, you know, the party without the resources, the one that always has to battle a bit more for itself. I enjoy that dynamic. In terms of your second question, I think that's a really good question because the ICC from the outside can seem quite impenetrable. And the institution itself, the ICC, is made up of these 3 branches. You have the Office of the Prosecutor, that everyone knows everything about, the chambers, so the judges, and then the registry. But independent counsel, so people like Dov and I who represent victims or accused, we're not part of that institution. We're not staff members. We really are independent. For me, that's really important, that we operate outside of the court structure, because as much as I would love, you know, sick leave or health insurance, I can see quite quickly where my job as representing accused would clash, would give rise to a conflict if I was a staff member. So we operate outside of the court, although the registry sort of administers us and in fact will pay us if our clients don't have any money. We're outside the court structure. So how do we become counsel? One of the parts of the registry, called the counsel support section, runs this thing called the list of counsel. And once you fulfill certain criteria as a lawyer, you can fill in the forms on the ICC website and you apply to get put on this list. And I looked it up this morning, and there are 894 lawyers on the ICC list of counsel and 1 Ukrainian. There's a list of legal assistants, so junior members of defense teams. There's 421 legal assistants and only 2 from Ukraine. And that's our fault. That's the fault of the institution. That's the fault of the ICC. The fact that the international criminal lists are so not diverse, not inclusive, is a problem on the ICC's end. And I think everybody's recognizing that. There needs to be concerted efforts to try and make sure that the lists from which accused can pick are much more diverse. And I have a lot of ideas about that, but I'm going to stop and see if Dov wants to add anything to what I've said, and maybe about how Dov became a defense lawyer, because I don't think I know that story.
Dov, could you share your experience, please? Thank you, Kate.
Yes, I think I have a slightly different background than a lot of my colleagues, actually, because I passed the bar in France in very long time ago, but then I decided to go in academia and I did a PhD and ended up in The Hague teaching. But I was always attracted by the defense aspects. I don't like things which everybody says are obvious in any aspect. You know, if everybody agrees on something, I'm going to think there's something wrong. That's my general, personality. So I think I'm pretty well fit for defense, because I don't take anything for granted. And so being in The Hague for teaching, I obviously doing international criminal law. I kind of, as Kate said, not really stumbled into it, but it wasn't a plan. Just happened that I was in touch with the Baghdad defense team for other reasons. And I kind of said, well, I'd love to get into the defense. And that was, the rest is history, as they say. So I slowly shifted, quite quickly actually shifted from full-time academic to part-time academic to now mostly full-time practitioner. And so contrary to Kate and others, I have actually fairly limited domestic practice. I'm one of those. And I think there's more and more of us who have, this generation of international criminal lawyers who have only international criminal law experience. If you take the first lawyers at the ICTY, CTRs are domestic lawyers. They came with a background of 15 years of criminal law practice domestically, which has its advantages, but also its disadvantages. And it was okay at the ICTY because the system was being invented as they went along by the judges, but also by the prosecutor and the lawyers. I think it's more problematic, and that kind of answers your second question, and maybe what is not the answer you're expecting. But it's a different job. Obviously, if you have experience in investigations domestically, if you have experience in being in court and cross-examining, obviously that's an added value. But you can't just think you can transition. And I think Kate has more things to say about that. But you can't automatically jump from a domestic courtroom to international courtroom. And this idea, I know it looks bad from the outside, but the fact is that if you are a very experienced domestic lawyer and if you want to jump into an international case, you might not defend your client adequately. That's a reality. And Kate said there's a list of 800 people and we should make it more diverse, and definitely. But we shouldn't sell the idea that everybody can become an international criminal lawyer. There are very few cases, and that's just not going to happen. It's a very specialized pool of people. It could be a more diverse pool of people. And in fact, maybe that's a question later, but if you look at the composition of the teams in defense now, actually in the past years, there's been a transition with, is it 3 or 4 female lead counsel now? A lot of the teams are 3, yeah. A lot of the teams, you have, if you add co-counsel, you can add 4 or 5, including Kate and Marie-Hélène. And so it's far more diverse than, it's not perfect, but it's far more diverse than it was a few years ago. But this idea that anybody can become an ICL lawyer and do the job right, the fact is, we can talk about diversity with Kate. If Kate and I were being accused before the ICC, we would take someone we know is competent. However much we like diversity, at least, I can't talk for Kate, but I would choose someone I know and who's done this before. I wouldn't try to, suddenly promote a young lawyer because everybody needs to get their chance. These guys are accused of massive crimes, are going to end up in jail for the rest of their life, possibly. They want someone who's done it and who's gotten acquitted and who's done the job before. And that's the reality. And just one last point on the on our link to the ICC, I have to agree with Kate, is that there are some of our colleagues who push for being more integrated in the institution. I disagree. We are independent. We shouldn't receive instructions from the registry, even though we do. When we're on legal aid, the registry can sometimes, in a very detailed way, tell us how we should investigate or use our resources, which is sometimes problematic. But we should have, the support of the institutions, the respect of the institution as a equal, footing as a prosecutor when it comes to what's going on at trial. But I don't think we should be formally integrated in the institution, definitely.
One aspect that both Dov and I skipped over, probably because it's obvious to us, but I should say, is that it's not us who say, I want to be a defense lawyer. the choice ultimately rests with the accused. The accused has the right to choose his or her own counsel. And so this list, this non-diverse list, is a stepping stone. Once you're on that list, the accused can then pick counsel from that list. Oftentimes, accused who come before the courts already have a lawyer, right? They have their lawyer from the Congo, they have their lawyer from the Central African Republic or Uganda, and they come with that lawyer. And the ICC actually really affords significant weight to the choice of the accused in their counsel, in their team. And if that person fulfills the criteria of getting on the list, that will happen, and it will happen quickly. But in other cases, the accused sort of have to fly blind and try and find someone they think is competent on this list. Very quickly on the issue of diversity, one of the problems that we have, and I'm amazed it took us 45 minutes to get here, is that the resources given to defence teams are not enough, actually. Not only are they limited, they're not enough. And so our teams are, we did Bemba with 4 people, the Bemba case at the ICC, 5 people, okay? Contrast that with what you can think is happening in the Office of the Prosecutor, where they have really large trial teams, and then an investigation division, and then an appeals division, and a witness protection division. And I don't have a problem with that per se, because the prosecution has the burden of proof, and that's a huge thing for them to carry. They have to prove these cases, and we don't have to disprove a thing. But when you're operating with a team of 4 and 5 people, Dub's right, people within that group need to have done this before, okay? And so that restricts the people who you can bring in who are new. And also, you're going to need people who share a native language with the client, which, normally isn't us. As Anglophones who speak French or Francophones who speak English, we don't have native languages of the accused. So at least 1 or 2 team members are going to need to have that link. So within that framework, Dub's right, there's not a lot of scope for us to have this wonderful cultural diversity within defence teams, the way that they can within the Office of the Prosecutor, because they have, a lot more roles to fill. But I don't think that's a reason that we shouldn't stop trying to be more inclusive, because, lawyers just coming from Europe or America or the UK, France, Australia, we don't have all the good ideas. There are lots of ideas in how to defend accused and how to approach aspects of war crimes that we haven't thought of yet. So diversity still remains important, even if I'm being idealistic. Those are the points I just wanted to add.
Thank you very much. And continuing the issue of diversity, I wanted to ask you about the diversity of the panel. How does the background of a judge, the regional, the gender of a judge, whether he or she practiced domestic law or was really involved in international law cases, impact the dynamics of the trial? And perhaps you could draw the examples from your experience. Thank you.
Kate, do you want to go first?
Sure. I mean, looking at gender first, I don't think the gender balance of the judges determines the way the case is going to turn out. Qualified judges are qualified judges. I absolutely think there should be gender parity on the benches, in the court generally, in law and in life. But I don't take the position that that should be our priority, making sure that there are just as many women presiding over these cases as men. I think the emphasis has to be on qualified judges who can run a courtroom, who can control this incredibly complex litigation. If there aren't enough qualified women getting through to the bench, that's a problem that we should address. But for me, it's the qualification above all else. I have a really different view when it comes to regional representation, because this is such a big issue. At the international criminal courts, you can end up with a panel of judges who come from markedly different systems. You can have a common law presiding judge with two civil law judges sitting on either side. And it's a very big issue because of how much of our criminal procedure at the ICC comes down to the discretion of the judges. Our rules of procedure and evidence aren't overly prescriptive. They're quite vague. And so the judges get to make huge decisions from themselves about how the trial will run, how you're allowed to question witnesses, what is the scope of victims' participation, how do you admit evidence, are you allowed to talk to your witness before they come on the stand. Those key aspects of trial procedure will be completely different depending on who is sitting on your bench. And in the first case at the ICC, the case against Thomas Lubanga, who was accused of recruiting and using child soldiers in the Congo, the presiding judge was a British judge, His Honour Judge Fulford, who ran his courtroom like a British courtroom. You know, he had very limited rights for victim participation. He had really strong remedies if the prosecution wasn't disclosing things. You know, walk down the corridor of the ICC to our courtroom in the Vemba case, which was presided by Her Honour Judge Steiner, a Brazilian judge, and she had a completely different take to trial procedure. She allowed very, very broad participatory rights for victims. She didn't allow us to cross-examine witnesses. We were only allowed to question prosecution witnesses. Now, one of these systems I'm more familiar with. I'm not going to say one of them is better or fairer than the other. But my point is, it's really hard for us as practitioners in that court to advise and instruct our clients when we have no idea what kind of trial we're going to be having until it starts. And undeniably, some aspects of criminal trial procedure are more favourable for the accused. You know, cross-examining witnesses, that's good for us. Proofing witnesses, speaking to witnesses before they testify, that's better for the prosecution. So there will be aspects that really impact on the fairness of the trial, and it comes down to who is your bench and where do they come from. And it's sort of this daily struggle that we have in this field about whether or not this should be regularized and normalized, and whether we should try and work towards a unified set of procedural rules. Dov?
Yeah, I mean, this is both one of my favorite topic, judges. It's also the one that gets me most into trouble. And I have to be particularly careful now that I'm a full-time practitioner. But I'll only say what I've said publicly. I mean, one of the major concerns which has been raised by myself and others at the ICC is the competence of judges. You know, that's kind of the elephant in the room, and it shouldn't be controversial to have to say that, you know, not all judges, this is meant to be the highest international criminal court in the world. I don't think anyone could claim with a straight face that all the judges that have sat at the ICC have had the level and competence to do so, and to do what, you know, Kate said, manage an international trial. So that's a major problem, irrespective of background at this point, or gender. And I think that's the main issue. You know, we can promote gender, and I think now it's 9-9, back to 9-9. But the fact is that now, once we've said that, we have to make sure, as Kate said, that we have, you know, 9 competent males and 9 competent females. You know, and you know, that's really important. And I made a proposal, not the only one, but a few years ago, is that, I don't know, I mean, I just explained, judges are selected by their states, and you have, as all diplomatic processes, it's not always based on competence. It might be the brother of the diplomat or the ambassador, and there's all backroom diplomatic, you know, negotiations going on. And that we can't avoid. At this point in time, we can't avoid. But judges are selected from 2 lists, list A and list B. List A is judges who have, let's put it simply, criminal law experience. Courtroom experience, criminal law as a judge, prosecutor, or lawyer. List B are judges which have experience in public international law, human rights. And putting aside the fact that some of the list A judges have not been very competent, but I think, and I've made a proposal that the list B should be removed completely. 99% of an international judge is dealing with minute procedural issues, day-to-day trial management, and I'm sorry, and I feel I can say that because I've gone through that. You can learn the rules, the criteria of customary law from a textbook. You can learn the definition of crimes against humanity from a textbook. You can't learn how to understand evidence if you've never been in a courtroom. You can't learn how to understand, you can't just learn from a textbook how a witness is reacting to an examination or cross-examination. This is not something you can learn in the book. And of course, as outsiders, when we look at international trials, what do we see? We see the big judgments, the genocide judgments, the debates about was it genocide or not, the debates about modes of liability, and recently we spoke about immunities of head of states. And I'm fascinated by that, but this is nothing in the work of the court. This represents virtually nothing in the daily work of the court. We need criminal lawyers in the broad sense. I don't mean lawyers in the sense defense, but we need people who have been in a courtroom. And until we do that, I think the quality of the justice at the ICC will not improve. Whatever other reforms and the 300-page report from the IER, etc., we will not improve the system until we have experts in criminal law in the courtroom as judges, defense, and prosecution. I won't comment on the other aspects that Kate did. Well, just one point. Obviously, you adapt to your judge. There's this famous quote that a good lawyer knows the law, a great lawyer knows the judge. You're not going to argue a point in front of a common law judge in the same way than a civil law judge. You know that if you make an argument about corroboration, about the admission, how you analyze a piece of evidence, a common law judge will have more sympathy for your arguments because there's a stricter approach to evidence in the common law system. Whereas a civil law judge just says, just give me everything, I'll sort it out. So when you tell a civil law judge, no, sorry, this is inadmissible because it's anonymous hearsay, which is, sorry, maybe I should explain. Anonymous hearsay is basically not only that it's not something you lived yourself, you're just telling a story that you heard from somewhere else, but you don't know where is that somewhere else. So, and I'm sorry, this is in transition to another issue, which would be applicable in Ukraine, is that human rights reports are typically anonymous hearsay. Because human rights reports say, in such and such village, something happened. Now, this is hearsay because often the investigator of Human Rights Watch or Amnesty International interviewed a witness, was not there himself. So that's already hearsay. And the report would not give you the source. So it's anonymous hearsay. And then a common law judge will cringe at anonymous hearsay. And so you can make an argument. A civil law judge doesn't care. I'm being a bit caricatural here, but it does change your way of arguing in court, obviously, depending on the origin of the judge.
Thank you, Dov. I think that's quite a frank statement that not all of the judges are qualified enough. I would say that you can feel that you got used to make unpopular statements that might be not very popular among other people. So I have a feeling that our audience is quite interested not in procedural issues, but rather in some psychological issue that you face while being defense lawyers at the ICC. And one of these questions is about that chemistry that appears between you and your clients. So it's obvious that you have some sort of relationship between you and the person that you represent and that you defend. So is it an obstacle? How do you tackle that? And is it a problem, or maybe it's not a problem from your perspective?
I think it really depends on the client, your relationship with them and to them. The first thing I'll say is that as defense lawyers, we are creatures of our instructions, is a phrase we use. We're a creature of our instructions. We can't just turn up in court and do whatever we want and say whatever we want. we're representing this individual and we get instructions from them to be able to act. So in order to build that rapport and trust and to be able to take effective instructions while still giving effective advice, you will develop a relationship with this person. Also, by virtue of the fact that international criminal justice is glacial, and I represented Jean-Pierre Bemba for 11 years, just by virtue of the amount of time that you spend with these individuals, of course, you will have some kind of relationship with them. And I think part of our job is harnessing that. I always say in the courtroom, and I used to tease my husband, who's a prosecutor, that we have the secret weapon. We've got the accused sitting right there behind us. And of all the people in the courtroom who think that they know what happened in relation to the events and the charges, the guy sitting behind you actually knows. And it's part of your job to use him, to get instructions from him, to make sure you sit down with him and know minute by minute where he was and what he was doing, and use that information to investigate the case, to go out into the field and get information that you can use to then test the prosecution's theory on the basis of the instructions that he's given you. You know, I think at its heart, that's the basis of the relationship. You have to keep in mind too that there is a human aspect to this, to the work that we do. And one of the things I find so incredibly unfair about international justice is that by its very nature, you are removing accused from their context and putting them in The Hague, potentially for 7, 8, 9, 10 years, the rest of their lives, in a context and environment that's completely foreign to them. You know, where they don't speak the language, where they can't worship in the same way, they can't eat in the same way, they can't exist in the same way. And I know you might think, who cares? Like, these guys are accused of international crimes. I don't care if they can't get their local food or listen to their local radio station. But it has this huge impact on the well-being, on the mental and physical well-being of these accused, to be detained for up to 10 years pre-trial, right? Or pre-verdict, while they're still found to be innocent. And it's very difficult for them to try and understand this new legal context that they're in, particularly in a circumstance where, let's be honest, their ability to have any in-person contact with their children, with their wives, with their family members is extremely limited. And so in that context, you as the lawyer are the person that they see. They're not seeing their kids, they're not seeing their wives. If they're sick, they're going to tell you. If they've got a problem, they're going to tell you, because you're their contact in The Hague. You're the person that they see every day. And, you know, one of our jobs is to try and raise these issues with the bench, raise these issues that come out of this long-term detention with no bail, with no provisional release, and make sure that the court is aware of these issues and can act to try and stem problems before they become serious obstacles to the mental and physical well-being of the accused.
As Kate said, when the accused are brought to The Hague and removed thousands of kilometers from their home and their families, lawyers are really important persons of contact. And Kate is also right to say that often in the courtrooms they'll be the only ones who know what's going on. Now, always saying the less positive thing is that your client by definition, it can't always go well with your client. You might disagree on strategy, you might disagree on certain things, and to put it bluntly, some defense lawyers I know would say that sometimes your client is your worst enemy. Because you're managing expectations also in terms, and Kate said international justice is slow. You have to understand, you have to make your client understand in a positive way that you know what you're doing. And knowing what you're doing is not necessarily what they expect. For example, you can't, and it's very sad to do that, but I'd say that a defense lawyer who promises that their client will get off quickly or soon, or that they'll get provisional release, would be lying. And it's a short-term benefit. Maybe you make the client happy for a few months until he fires you because you're not getting freed and your charges were confirmed. And so the job is difficult. But I don't think it's any less. Wrong expression. I think being a defense lawyer, and I have a lot of friends who are defense lawyers domestically, and it's hard. The relationship with a client is something which is special, but also hard, and which a prosecution doesn't have, and it makes the experience very personal. And it doesn't mean we should be associated with her clients, but it means that there is a human dimension which might be forgotten in the course of the trial. These people are presumed innocent. And even if they're convicted, they should be treated with respect and dignity, because it's not a reflection on them, it's a reflection on us as a society. The way we treat people, even if they're convicted of international crimes. So this human dimension can be forgotten. And Maria, if you allow me, you asked Kate this question, and I thought she would make that point, but I forgot to come back to it. There is no switch between defense and victims. It's not a different job, ultimately. Kate is a good example. She's defended accused and she's defended victims in Cambodia or Myanmar. And in SILK, my organization, we'll often represent affected communities. We do defense work, but also advise affected communities when there's allegations of war crimes and crimes against humanity. I don't switch hats. I'm doing the same job because I'm being a professional. And I think ultimately that's a link with a lot of things we said. How you can deal with this, everybody should be professional. You do the best job you can do, whether you're a prosecutor, a defense, a judge, in terms of finding the best evidence, analyzing the evidence. And, there's often this idea, especially at the ICC, it was not the case at the ICTY, I think Kate can say, but this idea of a strong distinction of the community prosecution defense. It's very, very, very strong at the ICC, whereas at the ICTY, people would talk much more in the corridors, and some defense became prosecution. At the ICC, there's really this idea of the bad guys. We defend the bad guys. We defend the scum. We can't be spoken to. And ultimately, and so you see very little defense lawyers or defense, even junior staff, who end up working at the prosecution. But that's short-sighted because we're doing the same job, ultimately, just through a different angle, but we are doing the same job.
Thank you very much, Dov, and I cannot help but voice the comments from the chat section that everybody is really in awe and grateful that you are so sincere and balanced in your opinions, and that you don't shy away from these inconvenient questions, which are very sensitive in a war-affected society. And I've got another personal ambience question coming from the members of the audience, and it's about the mental well-being and the burnout, not just of the defense lawyers, but any person, any professional involved in an international criminal law case. How do you deal with that? How long do you think a person needs to rest, basically, between one case or another? And generally, would there be any recommendations about maintaining one's mental and physical well-being while dealing permanently with this type of a job?
I'm always so grateful for these questions, because honestly, it's one of the only times we get to reflect on it. Because at the defense bar at the ICC, we are awful, terrible, F- at looking after our mental well-being. And I think it comes from this idea that's wrong, that if you start feeling affected by the events that you're talking about, killing, rape, day in, day out, it's very self-indulgent, because we're not the victims of these crimes. It's not my sisters or my mother or my friends who suffered these things. So who am I to sit here and feel sad about this? We should just get on with the job. And I think that's a mistake. And we always need reminders of this, because when you do get those sort of dark feelings, which do come, I think our natural approach is to address them with very, very dark humor or, you know, a lot of red wine. And I think instead we should be supporting each other. And, you know, it is our fault as a community for not taking it seriously, but also there's nothing offered to us at the ICC. No one is checking on us or giving us access to psychiatric help or any kind of counselling. So it's something that we need to do as a community internally, and we don't, and we should, because these cases take a huge chapter of your life. You know, you start them here and you end them in a different phase of your life, and you've learned things along the way and interacted along the way, not with just with victim communities, but with perpetrators. You know, a lot of our work is going into the prisons and talking to the people who committed the crimes that we're talking about and asking them, you know, why they did it and whether our client told them to, and seeing the crime base from both of those angles. And you do end up with at the end of a case with a very full head of terrible things. And even though you haven't lived them yourselves, I think it's always a good reminder that we should be more aware of the physical and mental toll it can take on us collectively as a group of lawyers.
Kate, may I quickly ask two small follow-up questions? Do you think that the slowness with which we recognize the impact of such cases on the people who work with it is that people think that it's just kind of unprofessional, that if I feel emotionally affected or engaged by it, you know, it's probably I'm not a very good lawyer, therefore I shouldn't admit it and I should just carry on. And secondly, you said that, well, you need to work with it basically more as a community. Did you mean the ICC bar? And do you think, or perhaps you have certain initiatives like that, you know, I don't know, mindfulness sessions or other initiatives you would provide for the members of your bar, and, you know, give the example also for the domestic lawyers. For us, this question for Ukraine is very topical for domestic investigators and prosecutors who A, have never faced, you know, the crimes of the such type, and B, they have never had the workload with these type of crimes of that scale. And therefore, I think domestically, Ukraine has really not addressed the issue of supporting the well-being of the investigators and prosecutors. And ultimately, of course, we will also speak about the well-being of the defense lawyers who proceed in the same war crime-related proceedings.
I think you're absolutely right, Katerina, that if you're sort of this busy defense lawyer doing this case, to sort of take a step back and say, I'm being very affected by what I'm hearing, does seem like not a good use of your time. It does seem, you know, just a bit, I think self-indulgent is the word that comes to mind. And that's wrong. And we should all take steps towards realizing that the subject matter is extremely difficult, particularly for lawyers, I would say, in a domestic context where the crime base is the context. You're living within a society that has suffered from the very actions that you're supposed to be looking into. So you can't divorce yourself from that. And I've spent a lot of the past 3 or 4 years working in the context of the Rwandan judiciary and working with Rwandan judges and Rwandan prosecutors and lawyers who, when I talk to them about what are the biggest challenges for you in hearing genocide cases or defending genocide cases, one day this judge said to me, the problem is that we lived this. Like, we can't disassociate ourselves from this thing that we lived through. We're coming to this from a perspective that we can never shake. So at the international level, you know, Dov and I are really privileged that we don't also have that layer on top of us. But still, you know, as a community, we need to be more aware of this. In terms of mindfulness, I mean, I don't know, Dov, what should we be doing? Probably something differently, but I haven't put my head up enough yet.
I'm probably too old school on this. I would say denial, which is not the way to go, probably. But I'll add, I mean, maybe more prosaically to what you said, Kate, you know, dealing day in and day out with horrible crimes. You mentioned Katerina as a workload, and Kate mentioned the size of the defense teams. The fact is that to be a defense lawyer, you work a lot, like ridiculous amount of hours. And I'm sure many professions can say that, but when you're a small team, Kate said 4 people on Bemba, we were, the core team on Bagbo was 4 or 5. The difference in available resources between defense and prosecution is crazy, And so you're working a lot, and maybe that's not a good thing, but we're passionate. That's also something which helps you be in denial. Suddenly the tiredness goes away, but honestly, it's not a good thing. The work-life balance, work-private life balance is not good, the ICCBA, I mean, you mentioned the ICCBA, it's been a discussion. We've had this discussion at the ICCBA for many years now in terms of support. And it's very difficult because even though the ICCBA is, I think, an important institution, which was created, 6 years ago now, it's trying to find an active role within the ICC. It's slowly been recognized as, a representative of both defense and victim representative at the Assembly of State Parties. But ultimately, you're stuck with the fact that each defense team is a small unit, okay? And it's complicated to take that into account because you can have a prosecutor policy in terms of sick days, sick leave, maternity leave. That's another issue, which is scandalous. There's no maternity leave for defense lawyers, female, obviously. But even paternity leave ones, there's no protection. But ultimately, each lead counsel is in charge of his own team. And it's a responsibility of lead counsel also to create a good working environment. But it would never be a 9 to 5. That's, again, maybe the unpopular statement. It's like not everyone can become an international criminal lawyer. It's not a 9 to 5. And even though you have to find the right balance with work life, it's also a personal choice you make. It's a personal choice I made. It's a personal choice some of my colleagues made. It's a personal choice that Kate definitely made, obviously. You are accepting that this is a job where you're going to some weeks work 70 hours or 80 hours, or where you're going to not see your kids for a few days in a row. I'm not judging. It's not better or worse. This is a choice we've made. And again, within that choice, I talk for me, I try to carve out moments where, for my mental sanity, I have time for my family and my kids, but the global picture is that I've made this choice. And if I want to, and I know I can say that now, sorry for my colleagues, if I want to have time for everything, I'd go back into academia and spend 2 years writing an article. But then, when the judge gives me a deadline for 4 p.m. tomorrow, I have no choice. I have to not sleep during the night.
I know that behind that door, which is next after you, there are your kids. So sorry for taking this time that you could spend with your kids from them. But before asking you the next excellent question from the chat, I would like to also say an important thing that seems important for me, because I think that your work is also important in terms of setting the standards for the defense team of also how they treat victims. It is something that Kate commented on. Why it is important, because when it comes to Ukrainian context, I have seen how lawyers that are representing those who are accused in the cases related to the armed conflict in Ukraine, they literally attack victims. They try to discredit those people who have already suffered from the situation. And that looks awful, I should say. And I think that it's inappropriate way of conducting for the defense lawyers. And maybe you can comment something on that. But also I would like to ask you to answer the question that I've already referred to, which is excellent. And I have to admit that this question comes from Nurine, from one of the participants of our previous webinars. and she currently running for the position of the judge from Ukraine at the European Court for Human Rights. Her name is Gayane Nurijanyan. I apologize for that. I was a bit confused. So the question is very concrete, and it refers to the recent changes at the ICC that we have discussed already as well. So we have a new prosecutor at the ICC, who is Karim Khan, who is actually former defense counsel. And how do you think this might impact the process at the ICC or the prosecutor's case selection or investigation strategy? And maybe you can comment something on this on these changes at the ICC in general also.
Yeah, just briefly. I mean, your first question is extraordinarily difficult, honestly. Now, I think we can all agree that whatever happens, you have to treat witnesses with respect and dignity. You know, there's no, in terms of tone, in terms of you know, how you approach their stories, you have to show at all times respect and dignity. The fact is that witnesses, and I'm sorry again to being prosaic, witnesses are evidence. And they participate in a prosecution strategy, a prosecution case to prove the crimes, to prove the conduct. No. There are two things. Either the witness and the victim that comes on the stand is bringing evidence which will put your client in jail, and you have a right, again, with respect and dignity, to test that evidence. Either, as Kate said, the crime itself is not challenged, and even the link is not challenged. And in that case, a witness should not be called. You know, there is this feeling, and I'm sure you're familiar with the Iceman Trial, where the prosecutor was actually criticized by the judge because he was bringing in many survivors of the Holocaust. And at some point, the judge said, how is this proving Eichmann's guilt? So the fact is that if the prosecutor is trying to prove an element of the charges with a witness who might be a victim, you cannot prevent the defense from interrogating them. That's just, you know, the idea that you know, we should just accept what witnesses say. And this is, again, that's why I'm saying it's an extraordinarily difficult question, and I'm trying to be very careful in answering it. But you know, there have been false testimonies, including from victims. It has happened. You know, it has happened at international trials. It has happened at the ICTR. It has happened at the ICC. You know, we had the issue in Lubanga of child soldiers lying about their age. It doesn't change the fact that they were child soldiers. It didn't change the fact that they suffered incredible atrocities and that they were in terrible situations. But from a criminal law perspective, it was necessary to test their evidence on their age, you know, and to question the fact whether they were or not child soldiers, because this went to the heart of what Lubanga was accused of. So it's a very difficult balance. You know, it's a very difficult balance. And I'll mention, and I know, again, a very difficult and delicate subject, but you know, the hardest situation that we know in ICL is victims of sexual violence and rape, because the protections, for obvious reasons, for those kind of victims are very high in terms of avoiding re-traumatization, etc. But depending on the circumstances, a defense lawyer might need to test their story. It's possible. You know, maybe it will be, as Kate said, that the rape itself is not challenged, or that it's part of the contextual element of the crimes. You know, that there was a rape campaign, etc., where you don't have to question. But it's happened in some occasions that some accused in international criminal law have been accused specifically of being the direct perpetrator of sexual violence. You know, and those issues are not new to ICL. All domestic lawyers will be able to testify to that difficulty. You know, when you have accusations of mistreatment of children, of rape and sexual violence, how do you have a fair process by fully respecting the dignity of the victims? So I you know, again, I'm trying to be very careful here, but I think it's important to find a balance. Is it always easy to find? No. And obviously I agree with your initial starting point, Maria, that it can't be aggressive. It can't be just, I mean, I'm sure Kate has examples. I won't repeat some of the examples I've heard in international criminal law, how some lawyers examined rape victims, but there have been examples of really inadmissible conduct. Just a quick word on Karim Khan. I won't say too much on Karim Khan. On paper, you would expect that Karim Khan has the experience of, what is wrong at the OTP, given especially his role as a defense lawyer. At the ICCBA, we wrote a questionnaire for the candidates and asking them, how would you approach certain issues like disclosure matters? You can find all those questionnaires on the ICC website. And the fact is Karim gave the obvious answer. He says, I know what's wrong with disclosure because I was on the other side. I know everything the OTP did wrong in terms of disclosure. So he should be able to be familiar with some of the things to fix. Now, whether he'll be able to, change some of the criticism leveled at the OTP in the past 15 years, I'm not sure. And not because of any incompetence, but the OTP is like it's like a big ship, and if you change course, it's not immediately visible. It's like, and sorry for the kind of sad metaphor, but given the criticism that's been leveled at the OTP in the many years, you wonder just how far is it from the iceberg as a Titanic? Maybe Karim is very competent, but he might be too late in relation to some of the practices of the OTP, which have not been great in the past 15 years. But I won't say any more, Kate.
I'm going to come back quickly to this question of testing witnesses, vulnerable witnesses on the stand. It will never stop being shocking to me how many people are willing to come before international courts and lie. For the prosecution, for the defense. This isn't me saying it. This is the judgments. You read the judgments and you see over and over again that judges were unable to rely on these witnesses because they didn't give credible testimony. In some of the Rwandan judgments, they go further and say that groups of witnesses have fabricated their evidence. And of course, in domestic criminal trials, you see different stories between witnesses, but often on a much smaller scale. This witness will say the car was blue and this witness would say the car was red. In international criminal justice, we regularly have situations where groups of corroborated witnesses will come and say completely different things. This group will say there was this horrific event and your client was at the middle of it. And this group will say that never happened and couldn't have happened. And the judges have to try and find the truth. And we talk about it a lot as international criminal practitioners about this phenomenon of lying for justice, we call it. And in the first case I did in Rwanda that I was telling you about, a group of prosecution witnesses came and testified very credibly that my client flew into the biggest football stadium in Kigali, the capital of Rwanda, in the first week of the genocide and gave a speech to 10,000 people saying kill the Tutsi, and then took out all these crates of machetes and distributed them to the militia. We knew that he wasn't in Rwanda during the first weeks of the genocide, and we went to the football stadium. We met with all the people who lived around it, and they told us no one was meeting like that in the genocide. You were either being killed or killing. You were hiding or you're at the roadblocks. There weren't ever groups of people in football stadiums. And this was my first case, and I was so shocked that one of these groups of witnesses were fabricating their evidence in front of these judges. And we see it often because witnesses will often line up along the same ethnic lines or religious lines or political lines that they were during the conflict. And if someone had killed my mother, or hurt my kids, you can see where this testimony comes from. They lie because they want justice. I'm not saying it's every witness. I'm not saying it's most witnesses. I'm saying it's something that the judges themselves see that they have to grapple with. And it's something that we have to be very, very careful with as prosecutors or defense lawyers when we investigate these cases. You know, another very quick story, I was investigating a horrific allegation against my client that he had been present during this sort of pack rape of refugees in Rwanda. And I was investigating that allegation, and then I came across this person who said, I'm your client's godson. My parents went to university, studied engineering with him, and he gave all these family stories and he knew everything. And most importantly, he gave me an alibi for this horrific attack. Very pleased with myself. I took a witness statement. I filled in the form. I took his photograph. I went back to the prison and I said to the clients, you know, I had a really good mission. I got lots of good evidence. And look, this guy, I found your godson. And the client's like, I've never seen that kid in my life. Like, do not call him. That's not real. It happens. This is someone who wants to help you, help your client who sees himself aligned. And you have to be really careful in ensuring, because we cannot put on evidence that isn't real. You know, it's not something we do or can do. But it's because these cases are so fraught with the weight of whatever the subject matter is, you have to fight really hard to get through all that pain that the communities are still feeling to try and get to the truth. I mean, this could sound incredibly cynical, all these things I'm saying, but it's the experience that I've lived over the last 15 years of having the privilege of working in these cases.
I think if I may add to that, and I think Kate might have experienced that, not to throw her under the bus in her work with Myanmar, but there's also this, witness fatigue, where especially, I'm sure you've lived this with Cox's Bazar, but I think we've lived it in every situation where by the time a witness is interviewed by the prosecutor, some of them have become professional witnesses. They've been interviewed by UNHCR, they've been interviewed by Amnesty International, they've been interviewed by local NGOs. And just to add, and that's not what Kate was saying, but it's not even, sometimes it's genuine. You know, there's not a desire to lie. But the fact is that when you tell the same story 50 times, it's not the same story at the end and at the beginning, because you've started the kind of spontaneity of a testimony is different. I mean, in the same way that, you know, when Katerina and I are teaching, I kind of improvise a lot of my courses, but after 15 years, some sentences just come out the same way. And people who hear me in conferences are probably thinking, you know, this is very boring because I make the same jokes and I say always the same thing. And I'm making the same criticism of international criminal law because my brain is now in automatic mode. And that's a real issue. It's a real issue with international investigations. No, the witness is not trying to lie. It's not, you know, consciously fabricating evidence. But because the witness said, you know, 3-4 times, and maybe at the beginning someone said, "Are you sure no one was there?" Maybe there was a leading question, and I'm sorry, I'm becoming technical, but that's really important. You know, maybe in the first interviews, the prosecution investigator as a defense, you know, asked a leading question. Are you sure this military unit was not in the village? Oh, I don't remember. Are you sure that they have this? And you have leading questions. And maybe the witness says, "Oh, yes, actually, they were there. I recognize." The next time someone interviews them, the witness will say, "And that unit was in the village." And so it's not, you know, it's a fabricated memory as well to some extent, which starts from a leading question and end up as a positive statement, an affirmative statement 3 or 4 interviews down the line. So this is really important also when you're investigating, you know, human rights violations and you expect this to go to an international criminal court. There's a human rights investigation is one thing, a criminal trial is something else. And I'm sure, again, I raised this because, you know, the starting point for a lot of those domestic issues is what can be done domestically to ensure that the trials and justice is done at the ICC. You know, and there's a lot of well-intentioned NGOs and groups who want to gather evidence, as much evidence as possible, but they are risking tainting the evidence for a future trial. And that's true in Myanmar, that's true in some of the situations Kate and I have worked in, and that's probably true in Ukraine right now, where well-intentioned NGOs and human rights lawyers might actually be creating a situation where the evidence they gather in the ways they gather it will actually not be as useful before the court as they would want to. So just wanted to add that on the kind of lying, fabricated evidence part. Thank
you very much, Kate and Dov. And honestly, we've got so many questions from the audience regarding the trials in absentia, regarding the investigations which the defense are conducting. But given the time, we will respect your time and your family's time. And we really want to thank you for your sincerity. I think it's the first time really that we have received so many comments exactly on the sincerity of the speakers and their readiness to be so bold and open to the questions that many people wouldn't conventionally take. So thank you so much for that. I hope you can have a work-free afternoon and evening, and hopefully we'll be able to invite you for other webinars as well, and especially also in person for more events here happening in Ukraine.
Thank you so much for your insights. It was really very interesting.
Thank you. Yes, please invite us to Ukraine. We'll be there. We'd love it.
Definitely. Thank you very much. And thank you for all the questions. It's always a pleasure.
Thank you very much. Have a good evening. Bye-bye.
Thanks, everyone.
Thank you. And I would also like to thank to our audience and for everyone who attended online our webinar, and to our colleagues. And please follow us on social media and follow our next events as well.